hands. Show me your hands now. Show your hands. Stay down. Show your hands. Turn around.
Right, stand there. Your hands up for me.
Turn around.
Wow, what's all this about?
Don't know, mate. Don't know what.
You don't know what it's about. You've handcuffed me.
Right, relax.
I'm relaxed. You relax.
Right, don't face me.
Don't face you.
Oh yes, don't
Why?
face me. You're getting aggressive towards me.
I'm getting aggressive because I'm asking why you've got me cuffed.
Yeah. Relax.
Well, tell me what's your grounds for having me cuffed.
Huh?
What's the grounds? You need grounds to. You can't just go up and members of the public, right, and handcuff people like this.
Right. From Bishopsgate Police Station, and PC Tutwell, we're searching under section 1, okay?
What's your grounds?
Grounds for yourself has been, or you've probably been seen with a knife, okay?
A knife?
That's why, yeah, potentially, yeah. That's why you're going to be searched.
Wow.
Once additional officers arrived, they escalated their response. With tasers drawn, they detained 2 individuals who were calmly filming on the sidewalk. The stated reason was a report of a possible weapon, although no evidence of such was presented or discovered. The claim appeared to originate from a private security source and was accepted without independent verification. The officers placed the individuals in handcuffs and referred to Section 1 of PACE, which requires reasonable grounds for action. Simply holding a camera in a public space does not meet that standard. Rather than verifying the information, the officers appeared to rely solely on the unconfirmed report. This raises concerns about proper procedure and lawful conduct.
What are you filming?
Is it illegal to film?
No, it depends where you're going to film and what you're doing.
Am I in a public place?
I don't know. When you're trying to go in buildings and in private
No one's tried to go. No one's tried to go in there, sir. I mean, don't forget. Listen, let me tell you this, though, sir. Right? Don't forget, you've got a phone call alleging that people have got knives. Have you found any knives?
No.
So people are lying then, aren't they?
Not necessarily. Well, members of the public. Members of the public said that. Doesn't matter.
It does matter.
You're going in and out of buildings you should not be going in.
Have you got any proof that we have been in any buildings that we're not supposed to?
We're checking the CCTV.
I suggest you do before you make stupid allegations like that, sir. What's your number, please?
I haven't made an allegation.
What's your number, please?
I haven't made.
You just told me that I've been trying to go into buildings.
No, I said the allegation is from public that you've been going in buildings. I haven't said I've seen you doing it.
So he said it's a knife. You were saying that was supposed to be going in buildings.
Members of public have told us. So that's all we're going by.
Yeah.
So that's it.
Okay.
Right. So all they're going to do is just take your details.
No, they're not. I bet they don't.
You're going to refuse to give your details.
I'm not going to refuse, but I'm on your blood.
After every pocket and bag had been searched without uncovering anything, a sergeant arrived and began making unverified claims. When one individual asked why they were being treated as suspects, the response was vague, "I don't know. You're sneaking into buildings and private car parks." There were no recordings, witness statements, or formal trespass reports, only a general accusation following an unproductive search. Then came a key exchange. One of the individuals calmly asked, "Have you found any knives?" The sergeant acknowledged, "No." The response, "Someone's lied." To which the sergeant replied, "Doesn't matter. Members of the public." This suggested that an unconfirmed report from a bystander had been treated as sufficient grounds for a stop and search, even after it was proven false. By then, the consequences had already played out.
To give my details, I will. If I'm not obliged, then it's not refusal, is it? It's not a refusal.
You don't have to give your details.
Yeah, so that's not refusing then, is it?
I'm not going to stand out.
Yeah, because you try to word things, don't you, man?
Does anyone... I don't know. I'm just asking because I don't know what's been asked of you already.
Sarge, listen, I'm not going to give you no hard time, mate, you know.
Just so you know, I'm not ignoring you. I don't want to ask you the same questions that officers have already asked.
No, I'm saying I'm not going to give you no hard time.
Has anyone asked this gentleman, or have you been asked what photos you're taking and what you're taking images of?
Sarge, can I ask a question?
Yeah, of course you can.
Right. Do you know the police, right? They work on what they know, don't we? We don't work on what potential.
I do. I work on potential. Right. I work on why are 3 individuals here taking pictures of vehicles parked at the back of buildings,
going up to the back of buildings. But
that's what I work on. That's not normal behaviour.
Okay.
Right? For me, under Section 43 of the Terrorism Act, we have a power to search you and search any images.
Grounds.
I have got grounds. I've just given you the grounds.
And let me tell you this, Sarge.
Plainclothes officers be taking photos of vehicles, and why are you at the back of a building coming up to into the back of this building. I want to see if you've taken
Because
images.
the security guard engaged me in conversation and asked me what I was doing.
Right, why did the security guard ask you what you was doing?
Because I was looking at that car there, because it's a sports car.
What car where? Oh, okay, right. For me,
That's all.
looking into the basement area of the back of a building is suspicious behaviour.
Suspicious is not against the law.
No, it isn't.
Right.
It gives us grounds under Section 43 of the Terrorism Act.
I know you're the same
to
now,
search your stuff. Right, so that's
You've
where we
already
are.
done that?
No, we haven't. We searched under Section 1 because we were told there was a knife.
Okay.
So you haven't been searched under Section 43(1.
No, but you've searched us, so you don't need to search us again then.
Well, we can search your images under
Yeah,
Section
but you've got it up. Right, listen, let me tell you this then, right? There's a memo that went about to all police stations, right, to say that photography in public is not illegal and
No, it's
shouldn't
not.
be used. And listen, let me finish though. This is the important bit,
Yeah.
right? And shouldn't be used less than to use Section 43 under.
But
Yeah, it does.
But we're not saying
And that's
that.
from-
You're
that comes from
taking
the National
images,
Chief
You're looking
Constable.
at images. Doesn't matter. Within the back of a back of a building, that's suspicious behaviour. And for me, that is covered under Section 40.
When one of the individuals calmly pointed out that police actions should be based on concrete facts rather than vague possibilities, the sergeant responded, "I work on potential." This wasn't a simple misstatement, it signaled a misunderstanding of proper legal standards. By law, officers must have clear, objective grounds before detaining someone. Potential is not a recognized legal basis. It risks substituting assumption for evidence. The sergeant then attempted to justify the stop by asking, "Why are 3 individuals photographing cars behind private buildings?" However, asking a question does not establish wrongdoing. Filming or taking photos from a public pavement, even a private property or high-end vehicles, is entirely lawful. Car spotting is a legitimate hobby, not a criminal act. The situation appeared to reflect a presumption of intent rather than an assessment based on facts.
You're going to be let go, but I'd strongly suggest, obviously, if you are filming and auditing, to be exceptionally careful with what you're doing, because we will get called back again, and it's likely...
And you'll treat us fairly. You'll treat us fairly, won't you?
Listen, that's what we've done now, haven't we?
No.
Now that you don't suspect anything, can I come out of this?
Of course I can, and that was what I was saying.
Yeah.
So,
Oh,
that's what I was
no,
saying.
that's unwanted contact. It's unwanted contact. Get off me, man.
Let go of him. Listen.
Don't talk like
Listen.
that. Don't talk to me like that, Sergeant. I won't talk to you like that.
Listen. That's all I've said. Listen. How's that rude? I'm asking you to listen.
If I'm shouting,
You're shouting, I'm
no,
not.
if I was shouting, you're shouting. Listen.
I'm just saying listen, because you're looking
Don't
at
lie.
Listen to me a minute, right? So, based on what I was being told, looking in the building, obviously my colleague's got some more information now, and we've had a discussion, and we agree, we all agree. Listen, we all agree there's not enough under Section 43. That's what I was trying to get to. We've got to that, right? But your behaviour, taking images and photos...
Is it illegal?
No, it's not illegal.
Well, there you go then, so will you stop saying that, please?
Because we don't know until we stop and talk to you and deal with it. We don't know until we stop and talk to you what you've been doing.
I got roughed up.
Even after the initial claim involving a knife was dismissed and the Section 1 search yielded no results, the sergeant continued to pursue the matter. One of the individuals explained calmly that when security personnel asked what he was doing, he responded that he was admiring a sports car from a public area. The sergeant even identified the car in question, yet still considered looking toward a basement window as suspicious behavior. This assessment appeared to be based more on perception than on concrete facts. Instead of reconsidering the situation, the sergeant used it as a basis to request additional authority. When reminded that suspicion alone is not grounds for detention, he acknowledged the point, but then introduced Section 43 of the Terrorism Act as justification for conducting another search. This invocation came immediately after admitting that the initial stop under Section 1 had produced no evidence. Rather than concluding the encounter, the officer shifted the legal basis, using terrorism powers to search the individual's photos. This raises questions about whether the escalation was procedurally appropriate or a response to the earlier search proving unproductive.
Putting cuffs on, that's your words, not mine. You was put in handcuffs for whatever reasons. I wasn't here when you was being cuffed, all right? So, but we've had a conversation now, so you've been stopped. The initial allegation for a Section 1 search was because we were told there were knives seen, that's why.
Sarge, listen, I don't feel as though we've had a conversation. I feel as though I've been shouted at.
Well, I haven't raised my voice, so you have, but I haven't. I haven't needed.
That wasn't, you know, Sarge.
That's right.
But Sarge, can I ask you just
I've asked you to listen, that's all.
Okay, can I ask ask you to listen then?
Yeah, of course.
Can you have a copy of my stop search? You're the sergeant.
Stop search you, but I didn't stop search you.
Because I've called him a clown, he doesn't want to give me it.
Well, it's your right to have a copy of that.
Well, tell him then.
So,
excuse me, clown.
Hello.
Sergeant said you've got to give me a copy of the stop search.
I said you're entitled to a copy of your stop
that's
search.
fine.
Yeah.
Go on then.
Now, I haven't got it on me.
Oh, you say yeah, more scalp.
Listen.
Create it. Listen to the officer. He'll explain, all right?
That's
He's
what
not
I'm
an
saying.
officer. He's not an officer, Sarge. He's a constable.
Right.
Right, he's still an officer.
No, he's not.
Do you want to listen? Do you want to listen?
Yeah.
Okay, cool. Give me your email and I'll do that. Or you can go in front of Bishopsgate Police Station and you can collect a paper copy. Do you understand?
See you later then. Ta-da. Are you getting a copy? Here you, he's got a copy, here. He's got a copy. You little tyrant.
Even after a full Section 1 search revealed nothing, and the officer acknowledged that filming in public is legal, he remained on the scene. His continued concern wasn't based on any specific action, but rather on where the individuals were standing and the direction of their camera, raising questions about whether that alone constitutes reasonable suspicion. With no grounds to continue the search, the officer maintained conversation as though something might still surface, repeating concerns about behavior as if they held legal weight. But by that point, the initial concern had been addressed. The situation no longer presented a threat, and the justification appeared to be unraveling. Next, as the officers left thinking the matter was over, Torb and his colleague decided not to let it go. They contacted HNK solicitors, prompting an official response from the police department. While there was no apology, the force issued a carefully worded statement. In it, they claimed an officer believed he saw what looked like a sheath, a vague and unconfirmed observation that led to the deployment of tasers, handcuffs, and a full Section 1 search. There were no weapons, no evidence of any immediate threat, just a claim treated as fact. The response only raised further concerns. The department stood by the handcuffing, detention, taser deployment, and threat of pepper spray, describing the actions as lawful and proportionate. The stated grounds? A face covering in a grey BAG. At no point did any officer confirm the presence of a weapon before using force. A full use of force incident was built on assumption rather than verified fact. Instead of acknowledging error, the situation was reframed as reasonable suspicion. But careful wording doesn't change the reality. The search and escalation were based on unverified claims. Eventually, the case was settled for £500, a quiet acknowledgement that the response may not have held up in court. Once legal representation got involved, the story shifted. From the moment tasers were drawn, the rationale for the stop began to fall apart. Officers escalated based on hearsay, and when the initial justification didn't hold, the sergeant raised the possibility of invoking Section 43 of the Terrorism Act, an attempt to continue the search under a different legal basis. Perhaps the most revealing moment came when the sergeant stated, "I work on potential." That comment underscored a concerning approach, one where established legal thresholds are replaced by subjective judgment. It led to an encounter involving detention, escalation, and compensation, all over a camera and a parked sports car. What should have happened? A simple observation, a respectful question, and a quick check, something that could have taken 30 seconds and resolved the situation entirely. Instead, the approach taken was to act first and justify later. This wasn't just one questionable stop. It serves as a broader reminder of what can happen when assumptions take the place of evidence, and when power goes unchecked. In the end, accountability only came because the individuals involved chose to stand their ground. Thanks for watching Rate the Audit. If you found this breakdown helpful, please like, comment, and subscribe, and be sure to check out Torb's channel, linked in the description.